Thank you all for coming today. To my left is Ann Wallace from La Trobe University in Victoria, Australia, and Phil Knox with KSA Consulting. And as I said, I'm Peter Kiefer. We really appreciate you coming in at a fairly early morning after the Library of Congress soiree. Before we get started, one last time, if you haven't done it yet, we do have electronic voting in this session. So if you've got a smartphone, log in on the command line of pollev.com/courtfutures. And if everything works out right, you should be able to come to the first vote that we'll be getting to in a few minutes. So with that, also the one thing is several folks have had problems if they go into a search like Google or Safari or something. It's better to use the actual command line to do this rather than going into, say, Google or Safari. We had people who went into Google and they created 5 or 6 new votes. It was very confusing. So if you go to the command line, it'll stick with the ones that we actually pre-formatted. So with that.
Okay, good morning. As you heard, I'm Phil Knox. For the next hour, we're going to spend some time in a conversation with you. And truly, this is interactive, as you've heard. You'll have the opportunity, hopefully, as I'll have the opportunity to pass the mic to you throughout, to get your thoughts on access to justice and access to the courts. We want to encourage you to envision the courts in the future and access to justice in the future 10 years out, as we've done with our survey. Future, and to give us some input and kind of stretch yourself a little bit and think of what things might be and envision those things 10 years out.
So good morning. As you'll see, we don't have a panel of talking heads up the front here this morning. This session is all about drawing on your expertise. We believe that as the people who know the courts, you're actually the people who are best placed to make these predictions.
We'll be going over some of the results of a survey that we have been conducting for, the last 4 or 5 years now. The current 2017 survey is out, and if any of you would like to participate in that, we have sign-up sheets that are floating around. Sign up your name and your email address, and as soon as we get back home, we will email an invitation to the 2017 survey. Also, we're actually developing the 2018 survey now. And if you can think of new items of the future that you think we ought to be talking about, please email me and we will probably be including that in next year's survey. Now, as part of the survey, as you can see, we have gone out and gotten results from a significant number of individuals worldwide. I think right now we have had 1,100 people over the last 5 years respond to at least one of our surveys. We send out scenarios and we ask folks to assess the probability of various scenarios occurring, and they assess them on a rating of 1 to 5. As you can see over here, 1 meaning it's going to be highly likely that it's going to occur. In 2027, the sun is going to rise in the east and all things will be wonderful. And then we go to likely, 50-50 chance it's going to happen. Don't think so. Highly improbable. So the scenario of aliens coming down from another planet, taking over our brains and eliminating the courts altogether didn't do so well. So then we take, and of course we simply average the results, and then we categorize them into these general sections. And so during the session, we'll be talking about some of the scenarios and the results of those that we have had. So,
all right. Using the Poll Everywhere app, we're going to ask your opinion of 3 snapshots this morning. involving the future of the courts. We asked some brave audience members, we've contacted them ahead of time, and they've agreed, they're mostly sitting up here in the front, to come forward and help us recite what we've put together as snapshots, alternative options for you to choose from later on and vote for. After you hear the snapshots, you'll have the opportunity to vote on the poll everywhere. And then, yes, we'll ask you why you think why you voted for one or the other. So moving forward, we'll have our first two participants read from their snapshots.
So we're going to ask Patricia Christie and Professor David Tate to come forward, please, and stand at the front. These snapshots are going to ask the question, will the courts truly embrace diversity over the next 10 years? And in order to sharpen our discussion, what we've asked Patricia and David to do is to portray court administrators from different hypothetical countries and two different approaches to this question. Over to you.
It's Monday, January 4, 2027, and I haven't aged a bit. I'm Patricia Gunderson, Court Administrator for a large metropolitan court in Sylvania. Over the last 10 years, we've come to realise that more and more cultural diversity has forced our justice system to make fundamental changes. Mass migration has become commonplace. Changing communities have meant more diverse cultures. We have chosen to embrace open access to the courts. We worked with different communities to discover their needs. We brought in local leaders to educate judges and staff. We now pay a premium to staff who speak any of Sylvania's several languages. Employees now take night classes to learn new languages, and signs and court websites are in several different languages.
I'm Court Administrator David Cross, and I haven't aged either. The last 10 years in my country, Centopia, the courts have resisted changing our fundamental purpose because of multiculturalism. Mass migrations, yes, but also pushback and a return to cultural nationalism, which stopped hordes of immigrants from coming here. That in the wall. Still, communities were changing and courts had to respond. We've worked towards open access, but only as required by law. Signs in courthouses are in our official language, not every dialect known to man. When someone comes to court unable to speak Centopia's official language, we call the interpreter's office and they send an interpreter if one is available.
My goodness, David. Do courts in your country even try to help struggling local communities? In Sylvania, we have staff who walk people without lawyers through the court process and even find non-legal solutions. We also have volunteer groups from the local communities help parties find social services. This helps people and takes pressure off the judges.
Boy, Patricia, must be nice to have so many bleeding heart social workers tripping over each other trying to help folks. Have you forgotten the main job of courts? Deciding legal disputes. We do not have money to pay for staff to hold people's hands while they come to that scary old courthouse. The role of a court is to be an impartial arbiter, and that's what we do.
Thank you very much, actors this morning.
Okay. To reiterate and distinguish the two, Patricia's snapshot A, courts are meeting with minority communities, handle multiple languages and dialects, find solutions outside of the court to assist litigants. Or David's rendition, follow legal requirements, rely on the interpreter's office to translate when possible, and be helpful but impartial. So a bit more like what we're doing presently. So before we vote, survey results, I'm going to give you some of the survey results that are kind of on point, but not as direct maybe, but what we've sent out before to those who have agreed to take our survey. Our current survey that was just completed, there's a scenario, courts are confronted by ever-increasing cultural and linguistic challenges. So far, 307 respondents have assessed this scenario as highly likely, if you remember that, the chart here at the bottom, with an average assessment of 1.7. And remember, the lower the number, the more likely the scenario. International respondents assess this at 1.8, with U.S. respondents closely there at 1.7. We're currently also surveying the scenario, courts focus on ethnic disparity. Interestingly, 287 respondents assess this scenario only at a 50-50 probability of occurring in the next 10 years. International respondents assess it at 2.7, and again, very close, U.S. respondents were at 2.6. So if you consider these two scenarios and what we have out there is for our survey and the responses so far, it might call to attention that our respondents see cultural differences as a growing problem, but still unclear as how to deal with it.
Okay, let's see if this works. Now it is time to take out your smartphones, and we're going to ask you to vote. So, snapshot A, courts address open access and cultural diversity beyond the legal requirements. We go out of our way to try and bring access to justice as far as we can to various communities. Or snapshot B, courts address open access, but only to the limit required by law and no further than that. So with that, see if this works. Okay, come on. Uh-oh.
That's not the question, that's right now. You got one of your other ones.
Here we go.
Well, yeah,
Oh, really?
yeah.
No, it should have changed just then.
Oh, you gotta refresh it.
You gotta refresh.
From Wealth Gap
Yeah.
University.
Can everybody here in the back that just refresh to get to this
Okay,
particular
look
question?
at this. Snapshot A is kind of going ahead. Snapshot B, wavering. Snapshot A, leading poll at the moment. Yeah. Okay. So we seem to be, snapshot A is looking about twice as likely as snapshot B at the moment on our poll. If you're a snapshot B person, time to get your vote in.
Yeah, we'll let this sit for a while, but there's probably 50 plus people here, but we'll have Ann proceed in a minute.
The two options?
The address.
Poll EV, POLLEV.com /court futures, all one word. COURTFUT. Excuse me, wait a minute.
It's a spelling bee.
So put it into the
So good.
phone.
COURTFUTURES. I could do it.
Peter, will this continue acquiring?
This will continue on until we up here arbitrarily decide, we've had enough.
All right. Let me, and to help it, and we see what some of the results are at this point. They're getting a bit closer, but to proceed, let me help with some dialogue amongst us here. Does the concept of courts addressing social issues for different cultural groups cross the line? Does anyone think courts lose their impartiality by doing this, and why? And I will work the room with the mic if any brave soul wishes to address that. Or just generally.
Does
There we
anyone
go.
have the
There's-
opposite view? Would you like
Yeah.
to tell us how you
Let me get
voted
back here.
and why? You've got Dexter there behind you, I think. And one there.
For me, it's not a question of whether or not I'll embrace diversity in my court. It's whether or not I can fund it. I've got to have resources if I'm going to reach outside of the mandate of the court. of what's required. And so if I don't have the resources, although I'd love to do it, and everybody in the court would love to reach out and do everything we can, with no resources, I'm kind of hamstrung.
So provide core services, but beyond that, you're not funded for it. You'd love to, but how do you expand without the money?
If I had the money, I would do it.
I was going to give. I'm glad he answered that question already because without the money, how do you also engage individuals who will sit at the table and say, "Why are we even doing this?" Because it makes us feel good. I can't afford to feel good. You only got limited dollars, and where do you put them at? And then the next one is, we see some of these social things happening, and we're talking about bail reform. That's been broke for a long time. We've known people that don't get out of jail because they don't have money, but we're only addressing it now because case maybe make it to the Supreme Court, made it to some state Supreme Courts, it's in U.S. federal district courts, so now we want to talk about it. And still no money for it. Still no money for it, so some courts won't even do it until it's mandated.
Yeah.
Let me ask this question and sort of reverse it because, I mean, can you see the cycle, the sort of negative cycle that can develop with this is, I'd love to do it, but I have no money. But then these communities out there going, you know, you guys don't even care about us. We are a distant pedestal, a fortress on a hill, an entirely different type of culture when we walk into the courthouse. And so they are continually alienated, which again, we'd say, oh, we'd love to do it, but we're never going to do it because we never have enough money. And we just become more and more separated from these communities. How do we address what appears to be kind of a negative cycle? No. Oh, there we go.
It comes down to good customer service. I mean, it comes down to the fundamentals of what we can provide with what we have. And we have good people. We hire good people, and we can provide good customer service and access as best we can. Mm-hmm. I don't think that money totally limits us in that ability. Mm-hmm. And we can provide language abilities for our constituents that reflect, we hire to reflect what our constituency looks like. Mm-hmm. And as a result, in my little county in Oregon, we have socioeconomic issues coming to the court clerks' mm-hmm. windows, and if we don't provide good customer service and empathy and all the good things that need to happen at that window, then we're a disservice to the community.
Mm-hmm. Okay.
So what I'm seeing is, I think Snapshot A may be slightly ahead. For those of you who voted for Snapshot B, I'm getting the impression resources are a big issue here for many of you. Would that be correct? Yeah. Mm-hmm. And a question maybe about what you can do, how far you can go without those additional resources. And the gentleman who just spoke, I think, reflected that view.
I think there's one last aspect to this too. As court administrators, we might feel like the left side is what we really want to do, but then when you sit with the judges, they're still of a legal mind and says, "What do I have to do?" And so that's that back and forth as well.
Yeah.
Oh, go ahead, right over there.
Charmaine Pemberton from Trinidad and Tobago. It's interesting that you raised this because I am a sitting judge in our court. And I think there's, at times, at least speaking in Trinidad and Tobago, there's a wide disconnect between the judge and the court administration. And I think one of the ways, both parties have to meet each other halfway. So probably it may start with you sort of impacting on the judge the importance of soft skills, even when the person comes before the judge. Even in terms of your own area, I agree with the gentleman who spoke, and there are things that can be done without having to expend money. Improving your staff's soft skills is a good start. Even, something as basic as putting up a sign, which doesn't take a lot of money, welcome to wherever, in another language that you know is often used by your court users. I think those things will go a long way.
Okay. All right.
I was just going to say, and I'm probably not the best person to speak about this if there's someone from California. I know that San Francisco went a long way when they created their self-help center to try to address every language, and they've actually won awards for multiculturalism, or access, if you will, to everyone that they could possibly serve. I think it is a bit of a cycle. I will comment, just my observation was that as you offer these services, people come forward, they know it's available, and so now you're getting requests for language services that you're not prepared to provide, possibly, and so it is kind of a snowball effect. But if anyone is interested, I would really encourage you to look at San Francisco, because they are doing a fantastic job with this. It does strain resources, so I think we need to find sources for those resources from outside, and I think that's what they've done.
And Billy Joe, thank you for that comment, and Judge, yours as well. And I think that probably if we had the time, we could identify another half a dozen projects, programs that were developed with the funding that we were given to work with, because that's just what we do oftentimes is in the courts.
Okay, we'll move on to the second snapshot.
So Alicia and Billy Joe.
So for our second set of snapshots, we're going back to Centopia and Sylvania to ask how we'll know if courts are doing a good job. And there's been a lot of discussion about performance measures at this conference, and I know there's going to be another session on it this morning, so it's a very topical area.
Okay, I was asked to role play, so hopefully I won't go over the top. It's Monday, January 4th, 2027. I'm Court Administrator Billy Joe. Over the last 10 years in Centopia, courts developed performance measures to display value for the country. Courts publish several different performance measures, but our three main measures are filings, terminations, and time to disposition. The measures are posted on our government website and are included as part of our annual budget. We are proud that our courts dispose of cases quickly. We also use the statistics that we gather to ask for more funding. Filing numbers regularly show increasing demand for courts.
Well, I'm Court Administrator Leisha Adams. Although courts in Sylvania developed performance measures to instill public trust and confidence, results have been mixed. They don't show how well courts deal with the true needs of parties. The measures were designed by court staff and lawyers, and they are for court staff and lawyers. Regular people, those who can't afford a lawyer, weren't asked how to measure court performance. Many people think courts ought to provide basic social help and not favour big companies and the rich.
Well, Leisha, I see we're back to social work again. I'll admit the measures don't charm everyone. Civil society groups complain that shoving cases through the courts faster and faster doesn't necessarily equal better justice. But these measures are the only way we can truly show improvement.
Well, I'm just checking. Do you ever run into a brick wall while looking at your measures? People in Sylvania want courts to have more open access to justice, and they define that as social justice. They want courts to make a level playing field for parties with big debts and little income. Closing cases faster doesn't give them what they really want or need.
Thank you.
All right, here we go. Summarizing what we've just heard on your left, snapshot A, more adherence to traditional measures. Measures are posted on court websites as they likely are now. Time to disposition is a paramount measure and essential for budget presentations, to say within the budget and present to our budget authorities. On our right, snapshot B, measures do not demonstrate customer satisfaction. Measures designed by those in the courts not by customers. And so that's more of, if you consider snapshot B as more of a move towards social equality. Now, to give you an example of some of what we sent out in surveys previously, in 2015, we presented the scenario in the next 10 years, national demographics dramatically change. And if you read beyond that, what we explained to the survey takers is multiracial, blended families, changing immigration patterns, and changing age cohorts. That's what we meant by demographics dramatically changing. 468 respondents assessed this scenario as highly likely, again using our scale on the bottom, at 2.0 average. Remember, the lower the number, the more likely the scenario. And international respondents were at 2.2 and US respondents at 2.0. And another scenario focused in one of our surveys earlier, jurisdictions will adopt common case management time standards. We ran the scenario in 2013 with 205 respondents said the scenario was likely at 2.1 assessment.
Okay. Once again, pull out your cell phones. I think this is time to vote. Snapshot A. Courts keep to traditional performance measures. One of the primary measures, paramount measures, is reducing time to disposition. Or snapshot B. Courts focus on cultural and economic disparity.
So I think we're starting to see a fairly clear trend there already. And I guess it is one of the challenges, about measuring the things that you have to be your priority for your funding, your argument with your legislatures, of course, and perhaps the task of developing performance measures to measure those things that may be seen as more nebulous, perhaps. Or harder to measure, harder to devise effective measures? Okay.
All right, any brave, yes ma'am. Wow, I didn't even ask a question. Hi.
Good morning. I think it's important to do both. And it may not be a hard stretch to do both, but measures are important because that's our core responsibility and statutory responsibility, and it is what we're funded against. But including just the number of pro ses, for example, how many in the public, how many interpreters did we use, to include that in our baseline measure. It will also help with funding that we are representing our community as it becomes more diverse. So I think it's important to use both.
Okay.
I think one really interesting thing about the traditional performance measures that a lot of people might not know, based on a product survey that we have sent out to tens of thousands of cases that have been resolved online, 40% of people responded that they would not have been able to make it to court had they not had the opportunity to resolve it online in a different forum with the same people. And so I think what is important to know is that these statistics are skewed. They are omitting an entire chunk of the population that doesn't have access to this, therefore they are not customers, therefore you don't even know whether you're serving them. And I think that was a very scary number to see. I don't think we expected it to be that high. So
Yeah, that's a fascinating statistic,
So what-
and it suggests there's an unmet market out there, perhaps, and we don't necessarily know the demographic composition of that market either.
Yeah, so what I'm hearing is that these performance measures need to continually to be updated and refined. Somebody mentioned before about the bail analysis, fines, fees, and bails. Now, I mean, you can be a very effective, high-performing court collecting bail money or having your sheriff's office or whatever collecting bail money, but if people feel that bail, as I've read some articles, is a tool to keep poor people in jail and let rich people out of jail, being really effective at that, I don't know, is that what we in the courts want to be all about? I think that's a really a question that we probably need to talk about at some point in time. And as you said, the performance measures may not actually get to that. Yeah.
Any other comments here? Anybody who was one of maybe our optimists who...
We've got one at the back there, I think.
Okay.
Making me walk.
Well, as part of my job, one of the big things I do is track our statistics in Nashville and get them submitted to our AOC. And one of the issues I've occasionally seen is sometimes when we get into the middle of doing stats, because they're so closely tied to funding, people kind of put the blinders on. And every now and again, you'll get a judge who, yeah, it's important to have the stats to make sure you don't have a judge who's taking a year or 2 years to finish a case. That should only take a couple months. But sometimes they get so focused on, okay, well, if I want to make it look like we need another judge, I need to close these cases out quicker, and I need to push the attorneys on both sides to, you guys need to be ready by this date. And it sometimes pushes us, I think, into bad habits. We get so focused on we have to meet these certain metrics to prove that we're being useful that we kind of are getting into a situation where we're pushing folks to finish cases that may not necessarily be ripe for trial.
Well, let me ask this. Can you think of any other tool or tools that courts could use that might be better to tell our story other than the performance measures we're using now?
Oh,
Ken?
Well, I think what we've seen here is that, at least in terms of case processing, that's probably what we're primarily focusing on the left. And I don't think anybody's going to think that that's going to go away in terms of importance. But court tools, for example, of the National Center for State Courts, Measure 1 includes issues of performance satisfaction that would go more to the issues on the right, the access and fairness questions. And that's not a particularly hard survey to implement and measure. So I know you have to force a question here, but I don't think it's a question of either or. And I don't think it's particularly hard to add the Measure 1 components to survey those, and you can add factors that deal with linguistics or whatever the other issues are that make people feel that they've had a chance to tell their story. So.
Thanks. Any other comments on this?
okay. We'll move on to our third snapshot,
Okay.
hopefully. Hello. There we go.
Okay, so in our last snapshot, we're looking at the courts and the growing gap between the rich and the poor. We introduce our two presentations, please.
It's Monday, January 4th, 2027, and I'm Court Administrator Elaine Jones. The gap between rich elites and the poor in Sylvania has grown. To respond, courts have led the way to a new role providing open access to the needy. Court staff became aware of how to assist parties of modest means. They realized that poor people are often in crisis and their court experience can be overwhelming. Poor people are less able to think creatively in long term. Court staff can assist by offering social service help that has been successful in the past.
I'm Court Administrator Eric Evans. Yes, the gap between rich and poor has widened in Centopia, and that is sad, but open access does not mean social justice. Open access is also not where we get our authority to decide cases. The job of courts is simply to apply the law. The law was passed by the legislature. If the law favors the rich, talk to the legislature. If there are not enough lawyers to represent the poor, again, take it up with the legislature. If the rich can afford high-priced lawyers and the poor have to come to court unrepresented again, take it up with the legislature.
Thank you very much to Elaine Brisbridge and Eric Silverberg for their portrayals. Obviously, what we're focusing on here is how the courts are affected by the growing gap between rich and poor, which we know from demographic data in many of our countries is an increasing gap.
Okay, thank you. And then to summarize the snapshots, you might say that snapshot A is courts take the lead, staff work specifically with poor litigants, provide pleadings that have worked in the past, and courts work with poor communities. And otherwise, what you heard from Eric is more of a pure application of the law. Courts apply the law regardless. Economic disparity is the legislature's problem, not the problem of the courts. To give you some idea of what this, we sent some surveys out earlier, and one of them in 2015, we posed a scenario: the gap between rich and poor becomes an overriding societal challenge. 467 respondents assessed the scenario as likely. The average was 2.2 as an assessment, and international respondents were at 2.3, and U.S. respondents were close at 2.2. In 2013, we ran another scenario. Courts maintain programs that guard against abuse of vulnerable populations. 206 respondents said the scenario is likely at a 2.1 assessment.
Okay.
Ready? Get out your cell phones for the last snapshot. Snapshot A, courts take the lead, offering equal opportunity for justice between the rich and the poor. They level the playing field. Snapshot B, courts apply the law regardless of whether it favors a particular economic strata. Yes, Ken.
Question, in interpreting A, are you saying that they...
I'm trying to find out in terms of what you're asking in A, are you saying the courts are going to change the law in order to equalize, or they're going to simply level the procedural playing field? Because I think that's a distinction that's
I think
worth...
you're going to have to say level the procedural playing field, but
not necessarily changing the law to
bend the law in terms of doing that, not change the law because they're not the legislature, but we would go and be creative.
Okay.
Being even more creative than we are now.
They're going.
Oh my goodness, you just couldn't wait to start voting on this
I like
one.
it. I like it.
So, we're seeing quite a number of you think the courts are going to be more creative. Very interesting. And I guess one question that comes to my mind as I'm watching these that somebody might like to comment on is if courts are going to take the lead and perhaps trying to be more creative in levelling the playing field, what are some of the ways that are open to you to do that within, you know, the boundaries of the law that Keith referred to? Anybody who's voted might have a comment on that question or another comment on why you voted the way you did.
Can anyone here share an example of how courts have taken the lead in assisting with services?
As you digitize more and more and have a set number of employees, one of the ways to make sure that you can continue to keep your staff employed is to innovate and provide more services. So one example is creating help centers where you retrain the traditional clerk to now have a public-facing role versus the behind-the-counter and behind-the-glass role. We also have to address the question of online dispute resolution. How much time, like the example up there of 40% of people couldn't come to court but have done this and haven't ended up being part of your performance measures. Well, that could be part of the process of your district attorney's office is going to want to maintain control, but those employees can be doing the online dispute resolution approval instead of being downstairs negotiating with people in front of traffic court. So those are all ways to improve access to justice that aren't inherently obvious, but we're already innovating and may not necessarily realize it because we're under smaller budgets and we still want to maintain the staffing levels that we've had in the past.
So let me tell you a story of something that happened to me in my court, and then I want to ask you guys, we'll use the old-fashioned maybe show of hands, about what you think would be appropriate, and maybe what's appropriate to somebody calling the court. So, true story. I get a phone call. I'm the civil court administrator. So, I get a phone call, first thing on the line, that this guy says, "You're the sixth person that I have talked to. I've been transferred over and over and over again." That's always such a wonderful thing to have happen, isn't it? So, this guy has a default judgment. He stopped paying his credit cards because he lost his job about 3 years ago. He just doesn't have the money to pay his credit card, and he's got a huge debt, right? So, the bank sold his loan to somebody else who sold it to somebody else, and now a debt collection agency has got this, so it's completely removed from the original bank that this guy was working with. And he gets me on the phone and he says, "Look, sir, what I need, what I think is justice, is to have the judge call the bank up and tell them I can't afford it. Once I get a job, I will be happy to start paying my credit card bill again." I'm going, that's not what we do here, sir. I am really sorry. But I have to say, for me personally, I went, you know, I could see that as an extremely reasonable thought, scenario for a regular person to think that this is what courts ought to do. Do you think that this is a reasonable thing for folks in the community to think that our courts ought to be doing that? And what do we do about that disconnect between what we do and what this guy reasonably thinks we ought to be doing? I'd really like to know. Anybody comment on that? Dexter.
I think when we start to have these meetings and we see these injustices or things in our community, we quickly want to galvanize what we call our stakeholders. And what I always say, why aren't we ever inviting the people affected to the dinner table? How come they never have a seat? We talk about them, we talk around them, we talk above them, but we do little of talking to them.
I think we've got another comment up
In the back, there's somebody.
You know, I think this is a good opportunity to talk about the importance of understanding what the other resources in your community provide and how you can appropriately refer people. Coming at this issue, expecting the public to understand specifically everything we do is probably not a reasonable request and perhaps too daunting of a task. But what we can do is understand where you would send that gentleman to get the services that he needs. In that instance, I would suggest you would probably refer him to some sort of low-cost legal services, like partnerships with your bar association, which every court should have. But there are other community entities that we really should be understanding the resources they provide. So when you get that particular call, you don't have to say, that's not what we do here. What you say is, here are some of the things that you could do, and here's how you would contact someone to assist you with that.
I think it's an excellent comment, but I want to throw it back to you, Renee, before you take away that microphone.
Take it.
How many courts do you know who do just what you have suggested?
I couldn't.
And I'm gonna be the one. I'm not sure we refer to social service or non-legal entities to provide help to folks like I just described.
Yeah, I certainly couldn't offer you a definitive answer of how many courts are doing that. I would agree that it's probably...
This is going to be a challenge for us.
It's probably not a lot. It's a different way of thinking than the way we've been thinking. But I would encourage all of us to consider understanding what resources our communities offer for our similar constituency. We all of these organizations have the same people accessing them for different aspects of a problem, and we should really understand how to make appropriate referrals to one another.
Okay, good point. There were several.
Lots of hands up the back there. I can see down there on this side as well. Lady there.
Thank you for your comments. It's a good point. And in our court, and I'm the clerk of Superior Court, and I'm an elected person as well. So I'm in the community a lot, and we hold town hall meetings, informational sessions, but and working with the bar associations and we have several and I'm in the Metro Atlanta area, that there's volunteer lawyers, Atlanta Legal Aid, and so, but as clerk, I have 2 pages of resources. Domestic violence is huge in our community, as I suspect it is all over, sex trafficking. And so I opened a women's resource center in my office as an advocate and a lawyer to go in with most women that are victims have no representation in court. And so we have one that every single victim that comes in, that is a resource that is right there, because that accounts for 1/3 of our case type. The public defender's office is also utilizing contract attorneys so that there is a continuation of representation, and we are trying not to let that fall through the cracks. But I have 2 pages of resources, anywhere from senior help to dog catcher, because I believe as a public servant, it is my obligation, although it is not all my statutory responsibility, but it is because people come, out of the 2,000 phone calls I get a day, 500 of them are for everything but they know we answer the phone, they know that we have a resource base, and staying connected with all of my constituents in my community has been very helpful. So I do a newsletter, and I put this information. I have an extensive website with additional links that are not necessarily court-related, but it is community-related, and it gives us an opportunity to answer those questions. We also have a family law information center for the domestic issues that folk can get free legal. There are attorneys that staff that. But I do believe it's my responsibility to offer resource help. So referring folks to that process. I serve on the Dispute Resolution Board and the Law Library Board. So those are other connections that we make to offer as resources. And our judges use the dispute resolution frequently. Some make it a mandate in domestic cases before you ever come to court, sit down with in mediation. So we can make referrals. I almost think at this point it's a responsibility, and then it helps the system at large.
Thank you.
Now, let me ask you, some of those services and programs that you mentioned just now, were those developed with additional funding or within your existing budget?
Most of these are volunteer-based. Women's Resource Center is a 501c3. Most of these entities have their own funding stream. We just connected and partnered. So I don't have to fund them. I did provide them space and brought them into my office, but they still have their own funding source. And they work on volunteer basis.
I think the gentleman...
And I got lucky and that I was trying to drive home a point that when we were talking earlier about working within our existing budgets or getting volunteers to do something or expanding the services we provide with our existing funding. So I was hoping that was the answer I got from her. I know this lady here had a point to make earlier, and then I'll go in the back maybe.
Thank you. I work for the state Supreme Court, and one of the planks in their strategic plan has to do with access to justice. And the problem in our state, it's not exactly a problem, it's probably everywhere, is that the resources are scattered. Our Access to Justice Commission has done a great job of working with self-help desks in our individual courts, but they're not everywhere, and so people don't really know about them. So what we decided to do is, and I work with the Law Library and the District Judges Association, we put together a list of resources, and we put it on the Supreme Court website under a button that says self-represented litigants, push here, basically. And then they can go to all of the different resources that we have. And we understand from the Law Library, which has a set of LibGuides, which they call it, for people who need help and can't do the research. They have some helpful guides. The number of hits on it went from 1,500 in one year to 6,000 after we put our website button up. And it didn't cost us anything except our time to do a little research. And, you know, we had the button up within a day once we linked all the resources. So that came from a request, actually, from somebody who was trying to find self-represented information in one of the parishes and couldn't find it. So now all of the parishes that have the self-help resources we have links on the website, and it was a pretty simple thing to do. It didn't take a lot. We didn't understand until we started looking how scattered that everybody wanted to come and ask, and it seems like it's one place to put the stuff together.
And as is typical, oftentimes what we learn is you get more from the people sitting in your seats at our presentations than you do from us, so that's why we try to help encourage the conversation. Was there someone back here?
There's a gentleman in the green shirt, I think. Yeah.
Where am I going?
Good morning. Just a comment and a question. So in hearing this, and I'm seeing the word "in the courts," which is kind of a very generic phrasing. When I'm hearing this, I always think of kind of a delineation between the court's administration and social services. So, I mean, when I hear these scenarios played out, I think there's the administration of your courts and your proceedings and things of that nature, and then there's the marrying of social services. So just kind of an observation and a point. And then the second was a question. In your scenario where the individual said that he didn't have the ability to pay, is there a process for indigency? Because I work for a Texas municipal court, and of course, if a customer called me, I'd say, well, sir, there are opportunities to resolve your citation through non-payment means.
If you want me to finish up the story, I mean, this was not a citation. This was a private debt collection company suing this individual for non-payment of his credit card. He was too scared to come to court. So it ended up being a default judgment. He was afraid to come to court and file, besides the fact he did not have, obviously, enough money to hire an attorney. So the debt collection agency has an attorney who's in the court practically every day, who processes these cases and is before the judge in a routine manner. And frankly, don't have any particular resource for this guy to go. And he can't deny that he owes the money. He owed the money. He racked up a big credit card bill. I don't know exactly why. And his only defense is, somebody please help me. Because I think he actually said he tried to talk to the bank, but by the time he talked to the bank didn't even own the debt anymore. And they said, don't talk to us. So the guy was completely out of luck, and I don't know. I didn't really follow up. I presume that there's now a civil judgment against him, and that collection company is probably processing him for garnishment of whatever funds he might still have, or taking away his car or something. So there was another comment over here on the other side.
Well,
nope.
No, I think we're
Everybody's
good.
free.
Well, let me ask this as I'm making my way back to the front of the room. Is it realistic for courts to be an instrument for social change or social justice? Go ahead.
I would say yes, Phil. I mean, that's how we got specialty courts. Communities who solve problems with drugs. Now we have veterans courts. We have domestic violence courts. I mean, those are all social issues. I think Deborah hit it well when she said she's involved. So our courts are making those efforts. One of the things I forgot to say is, how long does it take us, though? You know, how long does the problem have to present itself to us before we say, okay, it's time to take action? You know, sometimes we can be very slowful. And think about your technology. Think about the data you gather. Think about when you do it. Sometimes it takes so long to deal with the illness. The illness becomes everyday life.
Let me hit them in order here.
Right, I was just going to agree with that comment. I think that is exactly what happened with the specialty courts. But in order for additional changes to be made, I think that they have to be perceived as cost-effective or perceived as being cheaper than not doing it. And so that's the challenge, is to make the people who provide the funding understand that you're better off doing it a different way, and that it will benefit them in the long run as well as the users of the system.
So the challenge for that is finding ways to cost the long-term benefits of some of these initiatives rather than the short-term.
And I just wanted to add that the juvenile court was the original specialty court and should absolutely be about social justice.
Absolutely. Well, Dexter, in his comment, said, how long does it take? And my answer is, it takes an hour. And we have come to pretty much the end of that hour. So, for me to wrap up, we always end up our presentations with this: to be creative. If you want to get ahead, look back, sure. Even look ahead, but always look around you for new opportunities. And Phil, anything else to add?
Thank you very much. Only to say that as an Australian, it's been a pleasure to be involved in this session, because what I'm increasingly aware of as I come to conferences like this is that the issues that we face are to a great extent international. And thank you very much for sharing your expertise with me especially.
Okay, thank you. Thank you.